your lawyer hat and tell me what the other side would be saying as to what, why, do they cite bad cases where, something hasn't been applicable, or?
You good?
Hold on just a moment. If you would, repeat the question, but we're trying not to get in too much of an advocacy role or against any group here. But hit the high points if you want, and but do repeat the question so we get it on tape. All right?
Sure. The question that was asked was, there is an organization that is promoting a uniform statute where it essentially is asking they're asking the legislatures across the country to pass a statute that would prohibit a court from relying upon foreign law if that foreign law would violate tenets of the the state constitution, the federal constitution, or public policy. And the question was, what do those proponents say is the reason why we need this legislation? And frankly, I'll point out what happened in Oklahoma. Oklahoma passed a statute, and it was immediately challenged. They did a referendum, and it passed overwhelmingly in the state of Oklahoma, and it became a constitutional amendment. It was challenged in the United States District Court, and it was overturned as violating the Establishment Clause because it was and we're going to talk about religious law and how religion plays a part in this in a little bit later this afternoon. But the reason why I'm mentioning this is the Court of Appeals, in their opinion, this is the United States Court of Appeals for the 11th Circuit, said they couldn't find any examples of where this was a problem, and that they had even asked the proponents of the legislation to present them with some sort of an example of where this was a problem. And in the state of Oklahoma, there was never an instance like that. And we found ourselves here in Texas basically in the same position. We can't find an instance where a Texas court has basically gone rogue and enforced a foreign, made a decision based on foreign law that was to the detriment of one of the citizens of the state. And so there are some examples. For example, there is a case out of New Jersey where a local court basically the allegation was the wife said that she was being abused, and the court said, well, relying on Islamic law, said, well, it's okay because the wife is basically the property of the husband. Total mistake. And it was immediately reversed when it went up to the appellate court, but it was still a bad decision, which has been publicized a lot and was completely wrong. But that was one isolated incident, and quite frankly, you'll probably hear this phrase over and over, that this is a solution in search of a problem. And that's even been during committee hearings. A number of individuals have brought that to the attention of the various committees that have heard this.
Thanks.
And I think that probably brings. Brian, did you have something?
I just got a little bit
Okay.
more. A couple of things I wanted to mention that are specifically things that the Texas courts are able to address that might seem a problem if you were to come across them. For instance, there are countries in this world where a woman is not entitled to be served with process. Any male member of her family can be served with process, but she can't. Her infant son could be. A Texas court doesn't have to accept that. So you've got those bizarre things, at least from our standpoint, that can be corrected. I want to say one more thing about our legislative status now and kind of how we got there. The family lawyers of Texas, and I'm not talking about the political side of it now, I'm just in the the preparation and vetting of potential bills, changes to the code, is really very thorough, and family lawyers aren't any better morally than anybody else. We are different in the sense that our practice is different. We're always on all sides of all issues at the same time. What does that mean? Throw us a problem that has to do with a husband and a wife, and don't tell Carl or I which side we get, and we have to be prepared to deal with it when it walks into our office. So we're not going to load up the law in favor of something when we know we're going to have to defend it on the other side. So it's a very even-handed kind of approach as to what would best make the system work. And we've also been blessed over the years with a legislative contingent here in Austin that, even as it's rolled over, has had some serious family lawyers involved in the process. And that's how we end up. I can't speak to Oklahoma or Louisiana. Well, we can all speak to Louisiana because we know, but we can't speak to the other people, but we know what a good product we have here. And Carl was talking about the statute that we have where you can put in all these protections against abduction. Well, even in a Hague Convention order, you can pull some of those into the order to return the child. When you're doing a divorce decree, you can pull those things in to protect against abductions. It's a very, very solid system. There's always something that somebody overlooked. There's always something that could be tweaked. But it's a very, very good system. And it works very well relative to everybody else and relative to the difficulty and the complexity of the problem. So we're very blessed in that sense. We have a good product, and I'm kind of in the solution looking for a problem camp, but we're not here for politics.
One of the things that I think is significant in family law cases is that we rely heavily on mediation and reconciliation processes. There are sections of our family code that specifically deal with alternative dispute resolution. I believe almost every county in the state of Texas requires that a party who files for a divorce or a child custody case actually go through some alternative dispute resolution process before ultimately going to court. And the success rate is pretty good in those areas. I would say that probably upwards of 75% of family law cases, whether they're divorces or it's a child custody suit, actually get resolved through mediation. It is a process that allows the parties to have more control over the decision. They're not putting their personal life out there in front of a judge and letting a judge make the decision that's going to affect them. And quite frankly, a lot of judges don't like deciding who's going to get the washer and dryer and who's going to get the sofa. So they would much rather the parties sit down and divide up their property. And they also don't want to play Solomon. They don't want to have to be put in the position of trying to decide who gets the kids and who gets visitation. And they would much rather the parties work together, because the thing that's unique about family law disputes is it's not just like you go in for a contract case and once a decision is made, it's over with. In family law cases, decisions are made that people live with for their entire lives, whether it's the divorce settlement or whether it's who gets custody of the kids. And so the process of mediation and alternative dispute resolution is very integral to that. And here again, foreign law also becomes involved in this, because as I mentioned, it's not only the laws of particular countries, but it's religious laws that also impact this. And to talk about the process, to get us started in this, and to talk about the process of contracting to take decisions out of the court's hands and to either do it through arbitration or mediation, I think both Judge Henry and Judge Garcia are going to come up and speak on that.
Good morning. Thank you. It's an honor to be here. I really want to commend you for being here because this is a detailed, broad topic, and I commend you for spending your time this morning trying to delve into it because there's so much to it. And our topic, of course, is what happens when you go ahead and try to agree to solve your dispute, because most disputes truly get solved that way. And it's a fascinating topic if you really think about it, because you're talking about very basic concept. On one hand, you have the right to contract, and on the other hand, you have something that ought to have a situation where you protect children, where you have some reasonable type restrictions. I mean, you know, we're in Texas. We believe that a deal's a deal, that you have the right to enter into a contract as a free person. You have the right to make a contract with another person, and that ought to be a right that someone has, whether you're a CEO of a corporation or whether you're just an individual on the street. So protecting that is an important concept. You know, last Friday, the school finance case came out with the Texas Supreme Court. And I know you know about that, I've been talking about that, but also there was another case that came out last Friday called White. And basically, the Texas Supreme Court spent about a half a page explaining how important the right to enter into a contract was. And so when you're doing that, you have to have some reasonable restrictions because you are involved with children. And everybody knows what an arbitration is, correct? An arbitration basically is where you're sitting down and you agree to enter to present your dispute to an arbitrator, and that arbitrator's decision is binding. And so in Texas, if you go to an arbitration, the arbitrator makes a decision, and then the court most likely will put their stamp of approval on it according to the procedure, with some limitations. The first limitation of arbitration is that it can't be something that is grossly unfair. I think there was a case one time where the arbitrator was a member of a law firm of one of the individuals who was appearing in front of it. And the court said, no, that's just so grossly unfair. That's not something that we're going to approve. In the family law context, the concept is that a judge gets to look at the arbitrator's decision and determine whether or not it's in the best interest of the child and can approve the decision or not approve the decision. And in the family law context, that's what you have in your Jabry case, which is in your materials. It's just a straight-up basic arbitration decision. Our more common situation that we see is the concept of mediation. And you know that mediation is where the parties agree to go to a mediator. The mediator facilitates that agreement, and hopefully at the end of the day, you enter into a contract that resolves the case. There's a couple of limitations to that, generally speaking. The first limitation is there can't be fraud in the mediation. For example, you can't sit in a mediation and say that you have no assets when in reality in your back pocket you have a $1 million lottery ticket. And that way, if there's fraud in a mediation, then the court does not have to approve that agreement later on. Material misrepresentation that's false, that the other side relied on, intent to rely, and things like that. In the family law context, there's some procedural aspects that you have to make sure you meet. There has to be a bold print on the actual mediation agreement that says, look, this is irrevocable. It has to be signed by all the parties. It has to be signed by their attorneys. And also, if there's family violence involved in the case, then the court can refuse to approve the mediated settlement agreement if the court finds that it's not in the best interest of the child. And so you have a situation where there's a protection in case there is, undue influence and things like that. So I know that we're the only thing standing between you and lunch, so I'll finish up. But bottom line, just keep in mind when you're talking about agreements, what you're talking about is, number one, protecting the right to contract as free people, and then also making sure that there's some reasonable restrictions and some reasonable limitations and protections of people. Now, Judge Garcia probably has some more detailed stories on that. So.
I do have a few things to add, and I want to echo what you've heard before about Texas and the state of family law and the Texas Family Code. Texas is known as being on the leading edge of having best practices in family cases. And the reason for that is the deliberative process, the idea of accepting things that work well for families and not just accepting every flash in the pan trend that comes along, because we care about our families. One of the things that's in the Family Code that protects our families from government intrusion, from intrusion against well-meaning judges. I like to think of myself as a well-meaning judge, but I don't belong in somebody's household telling them how to parent. And I teach a family law class at SMU, and we talk about this delicate balance between the rights of individuals to determine how they are going to raise their families and the purpose or the goal or the goal of government to make sure that the citizens of the state and the children of the state are protected. And the perfect example is mediation or premarital agreements, even if you want to go that far. We call that private ordering, where people reach agreements about how they're going to function in their families. At the front end, they do it through premarital agreements. We're going to do these things in our families. Now, the parts of premaritals that tend to be kind of ironclad that you can't really get past are the financial decisions. You can't make a financial decision, on the other hand, to say we're not going to do child support. That's against public policy. We've already determined that that's against public policy. Any agreement regarding your children that's against public policy is not going to be enforced. On the back end, you go to mediation. And as the judge here said, if you meet all the requirements, that's an ironclad agreement. And there's a good reason for that. Let me give you an example. You and your spouse have children. They're 3 and 5. In your mediation, you all agree, we're going to send our kids to this private school because we think that's best for our children. I happen to like public schools. My daughter goes to a public school. I'm a product of a public school. And they come up to my court and they decide to prove up their agreement. And I hear, what, y'all are sending your kids to private school? I think it's in the best interest of your children to go to public school. I'm not approving this agreement, and either you go back to the drawing board and do something about public school, or I'll just enter that judgment. There are protections in the family code that keep me from doing that, because the Supreme Court has already established that people who are in the best position to determine what's in the best interest of their children are parents. And I cannot substitute my judgment for that. We have a case in Texas, in re Stephanie Lee, regarding the enforceability of mediation agreements and whether or not judges can step in and say, I don't think this is a good idea. The swing vote in that case talks about child endangerment being a possible exception to this ironclad agreement, so that we're not talking about the proclivities of one judge over the parents. We are talking about actual protection for the safety of children. That's really important, because if you start going off into an area where you say, my personal judgment should substitute parents, that's a very dangerous area to go into. It's an area that gives probably too much power to the government. So you need to think about it in terms of that kind of balance. And so I know the citizens of the state, including myself, are grateful that the government doesn't come in and intrude on my ability to make parenting decisions for my children, my child, even though somebody might not exactly agree with the way that I'm raising her. I think that's about it. I think we're breaking for lunch now. Mr. Bresnan's nodding yes, so